Hi, my name is Carrie from Carrie Spence Estate Plans, Inc., and I'm here to share with you the basics of estate planning. Estate planning can be so confusing, so daunting, so complicated, and there's so much information out there, and it comes to us in so many different ways. How do you know what applies to your situation? I'm going to explain how it works, so you'll know what to do to put your estate plan in place. Everyone needs one. Why? We need to take care of ourselves. We need to take care of our families. We need to take care of our friends. And when the time comes, we don't want the tying up of our affairs to be messy and chaotic. We want the tying up of our affairs to be organized and orderly. So let's get started. So what is estate planning? The word estate comes from the olden days when the rich used to own land and possessions, and they called that their estate. In modern days, everyone has an estate. It's your stuff. Your stuff, or formerly called your assets, real property, money, and personal possessions. When you're thinking about your estate plan, there's only two decisions to make. Who's going to handle things if you can't? And who's going to get your stuff when you die? Let's talk about probate. A lot of people ask about probate and what it is. Probate is court intervention. And what triggers a probate is if you have assets that are over $184,500. Why do we want to avoid probate? Probate is time-consuming and very expensive. For example, if you have $800,000 in your estate, your probate fees will be $39,000. That's $39,000 that won't go to your beneficiaries. And it'll take a year or two before your beneficiaries receive their inheritance. That sounds like something we want to avoid. I knew a woman who bought a house early in Marin, and her whole family lived in Marin, and her children lived there, and they wanted to stay there. But she knew they wouldn't be able to afford to buy in Marin, so she hung on to that house. And when she died, her house went through probate. And the children had to sell the house to pay the probate fees. That's a tragedy that would have been avoided if she had had a living trust. There are four main documents in an estate plan. There's a will, a living trust, a financial power of attorney, and a healthcare directive. So let's talk about the will. The will is used to name guardians if you have minor children. You'll name your beneficiaries, who's going to get your stuff. You'll name your executor, the person that'll handle things after you die. But wills are designed to go through probate if you have assets over $184,500. We know we want to avoid probate. And to avoid probate, you need a living trust. So how does a living trust work? A living trust is an entity, not a person. And probate law only applies to people, living or dead, not entities. So this allows your successor trustee to transfer your assets to your beneficiaries easily, quickly, and privately. Now, the trust has two purposes. Incapacity planning, that's where your trustee will handle your finances if you're incapacitated. And when the time comes, your successor trustee will transfer your assets to your beneficiaries. There are some things we don't put in a trust. We don't put in retirement accounts because that'll create a taxable event. But retirement accounts have a beneficiary, and beneficiaries always avoid probate. The other thing we don't put in the trust are automobiles. We don't put automobiles in the trust because insurance companies won't insure you if your automobile is in a trust. So we handle that by putting it in the will, and you'll name the beneficiary of your automobiles in the will. And when the time comes, your executor will go to the DMV, fill out a really simple form, and transfer the automobiles to your beneficiaries. Now we've talked about the will and the trust. The third one is a financial power of attorney. The financial power of attorney is an incapacity planning document. If you're incapacitated, you've named an agent to handle your finances for you. Now, we talked about the incapacity planning in the trust, but remember, we've left a couple of things out of the trust, the retirement accounts and the automobiles. So you need a financial power of attorney to handle those assets. So that's the will, the trust, the financial power of attorney, and the last document is a healthcare directive. Most people know what a healthcare directive is. It's where you make your wishes ahead of time so that your agent can carry out your wishes if you can't. Most healthcare directives, you can make a decision whether you want to be buried or cremated and whether you want to give organ donations or not. One thing people don't know is that California is a consent state. What that means is if you don't want to give organ donations, you must put it in writing in your healthcare directive. So how do we transfer assets to the living trust? Well, if you have real property, a deed will be recorded, and it'll be recorded in your name as trustee of the trust. That way you have complete control over it. And don't worry, there's not a transfer fee. It won't raise your property taxes. It's an exemption. If you have bank accounts, you go to the bank looks at your trust, fills out some information in the computer, you sit there for a while, then the bank has you sign some documents, and voila, your bank account is in your trust. Some things don't have a title. These things are only listed on the trust schedule, like a promissory note, certain types of businesses, personal possessions, and that puts them in the trust. People ask me, do I need a will if I have a living trust because the beneficiaries are in the trust? Yes, you do need a will. It's a special will called a pour-over will. It says, look to my trust for my beneficiaries. But if something happens that triggers a probate, like you leave an asset outside the trust, you'll need this will to go through probate. Let me give you a silly example. All your assets are in the trust. Then you win the lottery. And the shock of it gives you a heart attack and you die. And then the lottery check comes in, and it's more than $184,500. And so you have to go to probate, and the pour-over will take you through probate. There are two types of beneficiaries in a trust, and also in the will. There's a specific beneficiary, and there's a residuary beneficiary. The specific beneficiary would be like, I'm going to leave $8,000 to Aunt Flo, and then I'm going to give everything else to my children. So Aunt Flo is the specific beneficiary, and your children are the residuary beneficiary. If you have no specific gifts, then the residuary beneficiaries would be your children. What documents do you need in your estate plan? Everybody needs a will. Everybody needs a financial power of attorney, and everybody needs a healthcare directive. If you have assets close to $184,500, you need a living trust. So how do you get started on your estate plan? There's two ways. One, do it yourself, and two, an estate planner. The first choice, doing it yourself, you need a computer and you need a printer, and you go online to a service that provides estate planning documents, and you plug in your information in the database, and then you print out the documents. So the will and the financial power of attorney you can get from the service. And to make the will legal, you'll need two witnesses that will watch you sign, and that makes the will legal. In California, we don't notarize, we just witness. The financial power of attorney needs to be notarized. So you can go down to the UPS store and get a notary to notarize the document. they'll charge you $15 a signature. That's a statutory fee. The healthcare directive. If you need, the healthcare directive is a little bit different. With the healthcare directive, you can get that from the California Medical Association or Kaiser or your provider, and you can pen that one in, and it can be witnessed or it can be notarized. But what if you have a more complicated case? If you have assets that are close to $184,500, then you need an estate planner. You need to make sure your trust gets put together correctly. You need to make sure that it's funded correctly so that it will work. If you don't need a living trust, you can still go to an estate planner if you want to avoid the hassle and the stress of doing it yourself. Well, there you have it. And just so you know, we always answer the telephone, and we never charge to talk. We speak in plain English. We don't require you to fill out lengthy forms. We just ask you questions and put it in our system. We use legal documents that are easy to read and understand so that you can be involved in the process. We make sure your assets avoid probate, and we charge a flat fee. We don't charge by the hour so that you'll know what the cost will be right up front. People often ask me what inspires me to do this work. I'm inspired by you, by your stories, by your fears, by your concerns. I'm even inspired by your stress. And I'm inspired with how deeply you care for your families and friends. And ultimately, what satisfies me is helping you get the job done. If you need more information, please give me a call. My phone number is 415-453-5952. You can also reach me through my website, CarrieSpenceEstatePlans.com. Talk soon.